welcome to VarnVlog. And today I'm with Dr. Julie Suk, who is a legal scholar, author, and professor of law at Fordham University School of Law. She earned her JD from Yale Law School and her Doctor of Philosophy and Politics at Oxford University. And she's the author of several books, including We Are the Women, The Unstoppable Mothers of the Equal Rights Amendment, and the one we're talking about today, The Shadow Court, Rescuing Democracy from the Supreme Court, which will be out September 1st, 2026. So this should be coming out right around that time. Hello, how are you doing today?
I'm doing great. Thanks so much for having me on.
Yeah, we live in interesting legal times, and so it is not hard. Normally I would ask an author why they wrote a book, but I think it's transparently obvious why you wrote this book. So we can get right in it. So one thing that comes up immediately is in your opening chapter, you argue that the Supreme Court has transformed from a legal case decider into the primary constitutional lawmaker. One, how long do you think this transition has been going on? And two, how does this shift fundamentally threaten popular sovereignty?
Great. So those are great questions. And I think arguably it's been going on since pretty early, or there have been phases. So initially the Supreme Court was designed in the US Constitution, and you'll see language in Article 3 of the Constitution that says that all the courts, all the federal courts, the federal judiciary, including the Supreme Court, which sits at the top of the hierarchy, their power is limited, and their power is limited to deciding cases and controversies. You could have a major policy dispute, and indeed, you might have a very important and burning question about the meaning of the Constitution. In fact, George Washington once had such a burning question, and they thought, since these wise men on the Supreme Court probably knew the Constitution best, could he ask the Supreme Court? And the answer was no, because the Supreme Court and all the courts that are provided for in the US Constitution exist to decide specific cases brought by plaintiffs against defendants. And true, you could sue the federal government, but you can only sue the federal government if you have a grievance against a specific injury caused by a specific actor at a specific time and place. So if you think about that's what courts do, that's how we understand the judicial role. It's actually a little bit bizarre that here we are in the 21st century, almost 250 years into the life of the US Constitution. And we just kind of accept that the rulings of the Supreme Court make constitutional law, change constitutional law. So if it was constitutional law 5 years ago that there is a right to abortion throughout the land, the Supreme Court can, through a decision in a case, effectively change what the policy and the law of abortion is throughout the land, right? So one question is, how did we get here? And the first step towards that is actually a very early case decided by the Supreme Court itself. And you could see that case, known as Marbury versus Madison, as a case in which the Supreme Court took the power of judicial review. There was nothing in the Constitution that said that the Supreme Court could strike down laws that were passed by Congress on the grounds that they were unconstitutional. But the Supreme Court, in taking that case, in hearing and deciding that case, actually says that the Judiciary Act of 1789, it's a bizarre situation in which Congress actually gave the Supreme Court power to hear certain kinds of cases, which is how the Supreme Court ended up hearing this case. But the Supreme Court says, actually, Congress should not have given us this power, because to do so would violate Article 3 of the Constitution. To do so would violate the original understanding that the framers put in as to how power should be divided across appellate and the Supreme Court and other federal courts. So the Supreme Court takes that power in that case in 1803 in Marbury versus Madison, and in striking down an act of Congress, says it's emphatically the province of the judiciary to say what the law means. And in saying what the law means, in saying what the Constitution means, it turns into changing what the Constitution means, because the Constitution doesn't say a lot. There are so few words in the Constitution, and many of the words that are in the Constitution can have many different meanings. So they've taken the power to say what the law means, and it's amounted and evolved and grown into the power to strike down acts by our elected representatives, lawmaking representatives in Congress. And that's how the Supreme Court has become the constitutional lawmaker in chief.
Mm.
And I'll just say it's not just all of this happened in 1803 with Marbury versus Madison. Another crucial moment is in the 1920s, because then one thing, you see a huge transformation. From the beginning, Congress has power to decide which cases, as long as the Constitution authorizes it, which cases the Supreme Court actually hears. And the Congress passes a statute that's known as the Judge's Bill in the early 1920s that basically changes what the Supreme Court does. Before, the Supreme Court was basically like an appellate court. The Supreme Court that you see sit in all the states, all the 50 states have a Supreme Court, and those Supreme Courts have to decide the cases that land on their docket because somebody's appealed a ruling. So it goes to the Supreme Court and they have to decide it. And you might say that's how you understand what a Supreme Court does. They're the ultimate appeals court. But that's not how the U.S. Supreme Court operates. They are the ultimate appeals court, but the U.S. Supreme Court decides. And this is something that's consolidated in 1925 with the Judge's Bill. The Supreme Court decides which cases are the most important and have the most impact on the public and on the people. And so they decide to grant a writ of certiorari. So there are tons and tons of cases that the Supreme Court could decide, but they choose not to. And they pick only like fewer than 100 cases a year based on how important those questions are, whether they're statutory or constitutional. And by doing that, the Supreme Court, by deciding which cases are the most important because they have the most impact, because they affect the most people, because they answer the most pressing constitutional questions, that's another way in which the power to choose what's important and then answer it, and then to have a rule that applies to everybody across the country, that's another way in which the Supreme Court, instead of just being a case decider, because if you were a case decider, you decide all the cases equally that you were expected to decide on appellate review. That's how the Supreme Court has become this kind of national lawmaker.
Yeah, its role of lawmaker is interesting, and it's interesting in a few different ways. The argument for it is that you don't want to highly politicize legal apparatus. The obvious counter argument is what they've done has made a more highly a political legal apparatus. And I think you really got me thinking about something that I haven't really thought about before in the book, particularly this first chapter, when you highlight Kevin McCone's concept of numerical
McMahon,
excuse me.
Yeah, a political scientist.
Yeah, numerical minority justices.
Mm-hmm.
How does the appointment of justices by presidents who often lose the popular vote, confirmed by thin Senate majorities, which are often not particularly democratically representative either, undermine the court's democratic legitimacy? And how does that play into this view that the court is supposed to be apolitical?
Yeah, so if you think about the original design of the judiciary, you wanted people who could stand above politics because they're deciding cases. And even if they're deciding cases involving political actors, you don't want the judges to be beholden to them. And that's why they're not elected, at least at the federal level. There are many states across the country that have elected judges and elected judges on even the Supreme Courts of the states. But the idea behind the design was that you really needed to insulate their independence from politics. And, but I think just what we've discussed so far is the way that the Supreme Court has become the primary constitutional lawmaker for the country. And because the Constitution uses these words that could have such wide-ranging meanings like equality or liberty or due process, to just give a few examples, the Supreme Court ends up changing what the law is in ways that inevitably line up with political ideologies and moral values. And so now if you think about the Supreme Court playing that role, and maybe they weren't intended to play that role at the beginning, maybe it's a role that they evolved into and grew over time. If you think about the Supreme Court playing that role, and we are a democracy in which we believe in popular sovereignty, which you mentioned earlier, then it's a little bit of a disconnect that people who are deciding these contested moral and political questions are incredibly independent from representative democracy and politics. But it creates a puzzle because you don't want people who are completely beholden to politics. You want them to be at least a little bit independent. But at the same time, a lot of the Supreme Court justices are incredibly removed. They're incredibly removed in the way that Kevin McMahon, the political scientist, suggests. They're removed. They're a little too removed from electoral politics because we now have presidents that sometimes lose the popular vote but win the Electoral College. And you could say if they lose the popular vote and win the Electoral College, that's just this antiquated piece of our Constitution that you could say is kind of anti-democratic and doesn't really fit modern democracy, but it's the Constitution that we have, so we follow it. But you could see how having justices that are appointed by presidents who don't really have that popular mandate is problematic for democracy. And then in the past, at least the president won the Electoral College, right? They won a national election. And in the past, the Senate used to just confirm the president's choice by overwhelming majorities. But now you get we have so much polarization in Congress, which I think echoes the polarization that we're seeing nationally across political ideologies and political parties. And so now we end up with justices on the court that were appointed by a president who did not win the popular mandate by winning the national popular vote, even though they won the Electoral College. And then they get confirmation by senators. And this is another, I'll stop to say, the Senate is also one of these things that's in the Constitution and, very difficult, impossible, I would say, to change, which is that every single state gets 2 senators regardless of the population of the state. And so we, like the people of Wyoming, have the same number, even though they're 1/70th the number of people as people of California. But now if you think about the Senate being very unrepresentative and malapportioned, what the political scientist Kevin McMahon does in his work is show that these last few justices that have been put on the court and are part of the conservative supermajority of the Supreme Court were confirmed by senators who represent fewer people than the senators who voted against those justices, right? Because if you could get like 52 votes in the Senate, 51 or 52 votes in the Senate, but if you get 52 senators who represent the least populous states or sparsely populated states, because they get the same number of votes as senators who represent the most populated states, like California. So I think it is very interesting that now political scientists are kind of breaking it down and showing from the confirmation votes that you're getting a president who didn't win a majority of the country, if you just count people rather than states. and then, or electoral votes. And then you have senates, like Senate majorities that don't represent a majority of the American people either. And the overrepresentation of those people is then like compounded by happenstance, because if a justice dies, and then whoever is sitting on the presidency at that time gets to appoint the successor. Or if a justice chooses to retire, sometimes justices time their retirement based on who they want to pick their successor. So it ends up so that a president, some presidents get 3 appointments, and some presidents in the same 4-year term might only get 1 or 0, depending on when people die. And if the president who got 3 appointments did not win the popular vote and then got confirmations by Senate majorities that do not represent most of the American people, you end up with a Supreme Court that's really out of step and not representative. And not just not representative, like I don't think that we should have justices who feel beholden to the people in terms of the next election. They should exercise independent legal judgment. But I think it does mean you end up with folks on the court who are deeply out of touch and out of step with the values of most Americans.
Yeah. One thing that I noticed in thinking about the argument of your book was that this very undemocratic institution, reflective of the most undemocratic institutions in the United States government anyway, actually has helped make the other more democratic institutions in the United States government, like Congress, less democratic. For example, how does Supreme Court jurisprudence on voting rights and partisan gerrymandering actively foster both congressional inertia and also a less responsive and less democratic House? It's compounding the problem of democracy here.
Yeah, so this is a great question. I think that we've seen a lot of cases about the power of states to redistrict. So the Constitution does empower state legislatures to determine the time, place, and manner of congressional elections. And this has long been understood as empowering the state legislatures to draw the electoral maps for congressional districts, even though the Constitution also says that Congress can override the state legislatures' decisions with regard to how they decide to regulate congressional elections. But Congress really hasn't done much with that power, although it could. But the state legislatures now, what they tend to do is once they win some elections and they get a majority, then they try to entrench their power. So, and both parties do this. The Republicans win a majority, they draw the maps next time. It's their turn to draw maps in a way that favors more Republicans over Democrats. Democrats do the same thing. If they win a majority in their state legislature, they'll draw the maps to favor themselves. And sometimes this partisan gerrymandering has to the extent that we have a lot of racial minority groups that tend to vote for a particular party or another party, the partisan gerrymandering has a lot of effects on the racial, whether or not members of different racial groups really have a true opportunity to elect a representative that of their choice and who will actually be accountable to them. So basically, the problem is that the Supreme Court has been invited on many occasions to do something about partisan gerrymandering by striking down, especially when the partisan gerrymandering has a clearly racially disparate effect, to strike that down as a form of race discrimination or even seeing it as racial gerrymandering. But in general, the court has said if it's partisan, if they look at it and it's partisan gerrymandering, they say that that's a political question. And judges decide cases and controversies. They decide legal problems. They don't decide politics. That's the story they tell. And so therefore, judges have no business redrawing the maps at the state legislature or second guessing the state legislature's prerogative to cash in on their political wins by entrenching their power through partisan gerrymandering. So I think part of the problem is that the court takes a double standard. That is, they say, we're hands off of partisan gerrymandering on the one hand. On the other hand, what you see, and you see this in a recent decision, it's so recent I was not able to discuss it fully in the book because it went to press before this decision came out. But the Supreme Court decided in a case called Louisiana versus Calais, which was decided in May of this year, that when states draw districts to overcome a past of racial discrimination against Black voters, and lots of books have been written about that. This is something that is clear, that even though we fought a civil war to get rid of slavery and to achieve equal citizenship for Black people who lived here, for over 100 years, Black people were disfranchised even when they officially, constitutionally had a right to vote, or at least a right not to be denied the vote on the basis of race. So if state legislatures try to do something about that now, and state legislatures do try to draw districts to empower Black people because they want to comply with the Voting Rights Act, which is one of the few times Congress actually tried to do something to establish fair voting and elections, especially in light of the past of severe racial discrimination. Now the Supreme Court is saying when the state draws those maps to empower previously disfranchised groups like Black people, that's itself a violation of the Equal Protection Clause because they take a totally colorblind approach to the Constitution's guarantee of equality in the 14th Amendment. And the court has also said in that case, in the Calais case, that a state can't comply, or the state does not need to create these race-conscious districts in order to comply with their obligations under the Voting Rights Act. And what that meant was that the court essentially, on equal protection grounds, on rejecting a defense based on the Voting Rights Act, essentially says that at the same time that they're getting out of partisan gerrymandering, they're taking a very active role in striking down gerrymandering that's designed to overcome the past of racial injustice in this country. So the court is very selective about which forms of redistricting they're going to get involved in. And the upshot of those choices is that there's a lot of partisan gerrymandering that disadvantages Black people and other racial minority groups that the court is saying that's none of our business, we're leaving that alone. And then when states try to do something proactive to undo racial injustice, the court gets involved and says you can't do that.
Yeah. The seeming inconsistency, particularly lately, has been kind of wild to look at. And I've been thinking a lot about Trump versus United States and, which you mentioned in your first chapter, as well as many decisions of the court against Biden where the expansion of power seems so explicitly partisan that it's hard to ignore, but also it almost seems strategically unwise on the part of the court. But I'll get to that. I guess to start the question is how have these recent rulings like Trump versus United States expanded presidential immunity and executive authority in ways that reshape the balance of powers between the executive and legislative branches? And then how has the court managed to do that selectively depending on the president at hand?
So, well, I think that's definitely one reading of it. And I think so you might be thinking of a case like Biden v. Nebraska, in which
Right.
Biden tries to cancel student loans, and the court suddenly is defending Congress's power, right? And saying, oh, well, Congress, and they invent a new doctrine, the major questions doctrine. The court comes in and says, well, if Congress really intended for that statute, which was really about 9/11, the heroes, if they really intended for that statute to extend to like this kind of post-COVID maybe emergency, to extend to the forgiving of student loans, Congress would have said so. So it's sort of limiting executive power when Biden tried to use it in the guise of defending Congress's power. And you don't see the same kind of move. I mean, so recently, again, this is a case that I didn't get to talk about in the shadow court because it went to press before the Supreme Court decided Trump v. Slaughter. And Trump v. Slaughter is a case in which, a lot of times Congress tries to limit the president's ability to fire members of the, heads of administrative agencies, people who do a lot of policymaking work. And there the court is basically saying that Congress can't limit the president's power in that way. And so I think it's very reasonable for people looking at this to say the court is just being selective about when it's going to defend Congress's power versus when it's going to defend the president's power. Although overall, I think this court has expanded and has expanded in cases involving Donald Trump as president, the power of the president under Article 2. There are a lot of phrases in the Constitution that you might say are kind of like, boy, what do those mean? What does it mean to say the president shall take care that the laws are faithfully executed? And the court reads into that an enormous amount of presidential power to do things like fire the people who Congress has entrusted with achieving certain policymaking objectives. So I think maybe the problem is the court's selectivity that is evidence of the court's partisanship. Whereas part of the reason I wrote this book is that I don't think that the biggest problem is the court's hypocrisy or, the fact that the court flip-flops and is like lacking principle and is lacking consistency, that it seems transparent that the court, this Supreme Court majority seems to like Trump more than it liked Biden, right? And I think a lot of people will say that's the problem. They like conservative rulings, conservative outcomes better than liberal outcomes. So they decide abortion and guns in ways that align with the way that the conservative legal movement would want it. And I think that that's what's drawing attention to the problem. But the argument of my book is that the problem goes deeper. And it goes deeper to why do we have 9 people who are not even by design supposed to be democratically representative? Because by design, if they're just appointed by the president and like the least representative lawmaking branch, i.e. the Senate, then they're by design not democratic. Why do we have a body that's by design not democratic deciding issues that should really be decided by the people? Going to like what our values are as a vast multiracial democracy and diverse democracy, right? So why are and so my argument is that it's equally bad if you have a liberal supermajority deciding that the words liberty without due process of law mean abortion rights, which is what they did in Roe, which is what the court did in Roe versus Wade. And it was, it was highly controversial. And I'm a strong believer in abortion rights, but I think that in a normal democracy, these kinds of things should be worked out, maybe not in normal politics, maybe in constitutional politics. I think that what's normal is, in France, for example, in 2024 or 2024, right, like shortly after Dobbs was decided, they added an amendment to their constitution guaranteeing the freedom of voluntary abortion. And so one question is, well, why don't we amend the Constitution? Why don't the people have control over what the Constitution says and means? We don't. We entrust it to 9 people who are by design not supposed to be particularly connected to the people or representative. And because of certain, like the happenstance of, judges dying, justices dying, and someone who didn't win the popular vote happening to be president and are living in polarized times, we end up with a very unrepresentative conservative supermajority court. I think we have to think about the problem, though, not just as they're hypocrites and they're too conservative, but by design, we've allowed the nation and our constitutional tradition to evolve in a way that we entrust decisions that go to the deepest values of the people to people who are, by design, completely out of step. So how should we think about that problem? And I think that's where the shadow court concept comes in. Maybe we need different and more institutions that make constitutional law, that change constitutional law, that are not the Supreme Court.
Yeah, I mean, that got me thinking a lot. One is there are 2 things that I've thought a lot about, and the civil rights era court actually did seem to stop or dramatically slow down the amending of the Constitution, which I found fascinating. That thinking about that. And the expansion of powers. I too believe in abortion rights, but thought Roe v. Wade was both kind of arbitrary and frankly, even I was like, that law doesn't it's an implied right off of an implied right. That doesn't actually make that much sense. And I know what they're trying to get around. I mean, I know it's a compromise to not formally grant bodily autonomy, but because that would cause all kinds of legal things. But it's interesting to think about the progressive role in setting this up, and how just going back to when the court was good, for most progressive people would have been the late 60s, might not actually fix this problem at all. And the other thing it brought up to mind, and then we can pivot to the discussion of reforms and the shadow court and why these other reforms probably won't work, but is the Supreme Court's ability to invent doctrine which has the force of law, such as the doctrine of scrutiny, the major questions doctrine. And you'll hear people reporting this as if they've always existed, and I just go and look at it. I'm like, no, this was created by the court as a way for the court to come up with a heuristic for jurisprudence, but it comes out of nowhere. It's like the vibes of the court that year, and yet those are all treated as having force of law, even beyond stare decisis. Like me learning about the levels of scrutiny on cases and me going that's not in the Constitution or in any legislation that I know of anywhere. 9 peeps decided that. How do we deal with that? I mean, thinking about this, that seems like a major problem when the Supreme Court, in adjudicating law and coming up with jurisprudence for law, actually in some ways is creating new law beyond just case law.
Yeah. So let me unpack this a little bit. I think what you refer to as doctrine, with the primary example being tiers of scrutiny. I would I think doctrine is useful because it creates a transparency about the process of arriving at an outcome. So if you ask me, I'm the judge, and you ask me, does racial segregation in schools or the racial segregation in a new context, or some practice that is not officially racial segregation, but has the effect of separating people by races. Is that a violation of the Equal Protection Clause, ?
Mm-hmm.
Right? And I could just say, well, I'm in a great mood today. I had a bacon, egg, and cheese for breakfast. Yes, it violates the Constitution. And I think with judging, though, it's not supposed to be based on your politics or if you're in a good mood or I think that's what you mean by vibes, right?
Mm-hmm.
Like if you're feeling it. And I think doctrine is supposed to go against vibes, or it's supposed to discipline the vibes by creating, and not just, we're not just making it up today. We're building on many other opinions that were written over a period of many years, precedent. But it's not just precedent in terms of outcomes, it's precedent in terms of how do we go about answering a question like if you have a policy that's clearly or not so clearly, how clear does it have to be that it's having this effect on Black people that's worse than the effect on white people? How are we supposed to evaluate that? And the tiers of scrutiny, at least it developed over time. So if you have something that we're going to call discrimination, then you're going to strictly scrutinize it. What does it mean to strictly scrutinize it? You're going to be very skeptical, and you're going to require the government to give an explanation that we call a compelling state interest. And no matter how compelling it is, you're not going to accept it unless the government also shows that it's narrow, that they really have to do it this way, that there's no other way that they could achieve their compelling state interest. Right. And then there are all these other subsidiary questions like, what does compelling mean anyway? Also, what is discrimination? What is discrimination, which is the thing that triggers strict scrutiny? Is it just classification, any form of race conscious behavior? Is it the effect? So these are all very difficult questions, but by having doctrine, you require judges to show their work instead of going on vibes. At least that's so. In principle, I think doctrine is good. It's supposed to be the counterweight against vibes. But of course, all the doctrine is invented. It's not written into the Constitution. The Constitution has very few words. So it doesn't say. And it's interesting because there are other documents that were written not in the 18th century, other constitutions or human rights treaties, like the European Convention on Human Rights, that were written in the 20th century that actually write some of the doctrine into the text, right? So they say you can't abridge this freedom unless it's necessary in a democratic society. That's a way of putting some piece of strict scrutiny into the text of the actual guarantee. And you'll see this in state constitutions too. In some state constitutions, for example, there have been a lot of amendments written after the Dobbs decision. There were state constitutional amendments that protected reproductive rights. And some of those amendments were written with a strict scrutiny language in the actual text of the Constitution, where it says you can't abridge the reproductive freedom unless there is unless there's a compelling state interest and it's narrowly tailored, or unless or you can't do it in a way that causes an undue burden, which is a variation on the tiers of scrutiny theme that you could get out of a case like Casey versus Planned Parenthood, which was the law before Dobbs overruled all of it. So in general, I do think that doctrine, so I guess I disagree with you about doctrine being vibes. I think that doctrine, when it's done properly, is not vibes. But the problem, as this conversation shows, is that you're showing work, but in every step of the work you're showing, there's some very controversial question that's going to come down to someone's intuitions or someone's just moral values.
Right. Yeah. And adjudicating between case law.
And if you believe that that's inevitable, so as I do, I think that's inevitable. And if you believe that that's inevitable, then there's so much you can do to get judges to lose their vibes. Maybe the other side of the coin is try to pick judges whose vibes line up with the democracy that you live in. And if you want to do that, then, so for example, the idea behind the shadow court, and it's not a random idea, I'm looking at a lot of constitutional design from the 20th century in many other countries. If you want to discipline those vibes, instead of just using doctrine to discipline the vibes, then why not have both the Senate and the House be involved in confirming the justices? You know, why not have ratification by a popular vote? I mean, that's not something that I explore in the book, because I try to limit the book to ways of doing this that would not be struck down as unconstitutional. And that's that's another puzzle that that the book tries to solve. But at least if you just look across the world, there are constitutional courts that decide constitutional cases that are separate from the Supreme Courts of these countries. And in almost every constitutional court, it'd be unheard of for only one chamber or only the upper chamber of a bicameral legislature to have a say in who gets to be on a court that inevitably makes policy type decisions. And inevitably, even when they're doing their best with doctrine, ends up making some judgments that are like vibes.
Yeah. Well, you know, I deal a lot in education law, which means I deal a lot in case law. And it's just part of my day job because I'm a department head. I work with a lot of special needs groups. And case law can feel, even with good doctrine, remarkably random depending on the federal district that you're in. But it makes what the Supreme Court does very obvious to me in a lot of ways, because a lot of times, you know, because I've moved around the country, I've been around the world actually, doing education work, and I will discover that like different district courts will have radically different interpretations of the responsibilities of like the IDEA revision or whatever. And so just because you think you know the law where you learned it, yeah, for me that would have been the Southeast. You move to a different district and you're just like, wild. This is completely different. Another example would be like guns on school property, where, you know, I live in a state where I can't break up a fight, but I could bring a concealed carry weapon to class legally. And that's like long-standing federal district thing here, but was unheard of until very recently in the Southeast. And I bring all this up because it does both make the case that what the Supreme Court does is really important. Otherwise, you get like really disparate case law. But you know, why a lack of oversight or clarity on things like doctrines are important too. And I brought up doctrine because I agree with you. Doctrine's actually super important, and it isn't a chance. Like, you're at least showing your logic, right? But we treat it as if it has the force of law a lot of times when I hear legal commentators talking to the public. And it kind of doesn't, because it like a court can change their doctrine pretty easily. And for the exact reasons why you say, because I could just interpret every word in the sentence differently. I'm an English major. I know how to do that. So I think a lot about this. So when you talk about the shadow court, I want to get to that because it's obviously a point of the book, but I do want to like bring up two questions before we do. The first one is, you know, during the Biden administration, there's this massive panel called about reforms for the Supreme Court.
Yes.
And
actually, this book, I was invited to write testimony for that commission, and this book like grew out of the 15 pages I wrote.
Okay.
For them.
So that makes sense. So a lot of these reforms, you know, from term limits to court packing, seem to me to be like, I don't know, they didn't seem to actually get deep enough to the problems of the court, even at the time before I read your book.
Okay.
And I wanted to ask why you think these don't, because I'm just going off, they're my vibes here. I'm just going off my intuition. I have a basic background in, like, I studied law thinking I was going to law school and dropped out. That's my level of understanding. So more than a layman, but less than a professor. And I often can't figure, like, I just have this, like, no, that doesn't feel like that's going to work, or that's going to be weaponizable in ways we don't see. But I don't have a good articulation other than those kind of vague inclinations. Why do you think that they don't really address these deeper flaws?
So let's start with court packing, which I think is a derogatory way of talking about. In some ways, it's a very sensible solution. We should have more justices, expand the court, right? Although I think every time that expanding the court has come up, it's been court packing. It's because the person who's proposing it is unhappy with the decisions that the Supreme Court has been issuing. Historically, it was FDR, when the Supreme Court was striking down New Deal policies, that the FDR said we need to expand the court. And that they didn't end up expanding the court in the 1930s. But certainly now, like, the discussion about expanding the court has been as, like, we need to add more justices so that we'll have a counterweight to the conservative supermajority that's been deciding all the cases that we opened by discussing. So the problem there is that if you just expand the court without expand the overall constitutional structure by which justices are named and appointed, it's still the president and the Senate, and it's still life tenure. And I think part of the reason the court expansion is an attractive idea is that it's, of all the things that have been circulating, it's the only one that you clearly do not need a constitutional amendment to achieve, because the Constitution doesn't say there are only 9 Supreme Court justices, and Congress has control, and Congress has changed the number in the past, right? So they have complete control over the number of seats there are on the Supreme Court, and you don't have to amend the Constitution. If you compare that to term limits, the problem with term limits is that a lot of people think that it's like a great idea from a pure political theory standpoint. It is a little insane that people can stay on for life when people live a lot longer in the 21st century than they did in the 18th century when the Constitution was written. The problem with term limits is that the Constitution says that judges serve during good behavior, and it's long been understood, like from the beginning, that that means life tenure. So people say you're going to have to figure out some way to do this without amending the Constitution, or you're going to have to amend the Constitution, which is impossible. And we could talk about why it's become impossible to amend the Constitution. That's another topic. I'm writing another book about that after this one. But so I think that's why people try to focus on expanding the court. But I think if you think about the problem of constitutional design, if you expand the court, it means that if there's a Democratic president and a democratically controlled Senate, then you'll achieve the effect of creating a counterweight to the conservative supermajority. But as soon as Republicans or conservatives win the presidency again and win back the Senate, and or have enough of a trifecta, control of both the House and the Senate and the presidency, they'll just expand the court again. So it could just keep going, and it'll definitely politicize the court even more than it is currently. So as a long-term solution, you might worry about it. And the real reason to worry about it is that if you think about the Electoral College, which we use to select the president, and the malapportionment of the Senate, it's just more likely that conservatives will always control the presidency and the Senate in the long run. So I don't think that expanding the court is going to solve the problem that a lot of liberals wanted to solve, even though it seems good short term. And maybe the seems good short term is really the best we could hope for under the existing Constitution. So if Democrats win both houses of Congress and control the presidency, and they have a window of opportunity, maybe that's just like the best possible thing. But that speaks very poorly to the horizon of possibility in which we live.
Yeah. That brings me to one more question, which is really kind of about your second chapter, but is directly related to this. And then we can pivot to talking about the shadow court. And that is, when historically has Congress been able to assert its own independence in interpretation of the Constitution and of law against the judiciary? Has it really been able to do that? And if it has, what can we learn from those examples? Because we seem to have like completely abandoned anything like that by the middle of the 20th century.
Well, arguably, I mean, there have been different moments, but what happened after the Civil War was that there were many amendments that there were leaders in Congress after the Civil War that made sure that we wrote constitutional amendments that not only guaranteed equality, abolished slavery, guaranteed that the right to vote would not be abridged on account of race. So we did those things substantively, but all of the amendments that I've mentioned came with a clause that said Congress shall have the power to enforce by appropriate legislation. So, and if you think of that, then it's not just the court saying what violates equal protection. It's Congress saying we're going to write a massive and transformative Voting Rights Act, or a massive, and of course the Voting Rights Act came like 100 years later after the constitutional amendment because Reconstruction ended. But at least the vision was Congress saying, first of all, we're going to control the states, because if the states start depriving people of their voting rights or depriving people of equal protection, Congress is going to step in and write federal laws that try to solve those problems. And implicit in that is that Congress is in the driver's seat of what does equality mean? Because at least right now, you have a Supreme Court that says equality means colorblindness. So if a state university tries to have race-based affirmative action, that violates the Constitution. That's the SFFA versus Harvard case from 2023. So the Supreme Court is saying equality means colorblindness. What if Congress were to say equality does not mean colorblindness? Equality means color conscious, to make sure that we undo the past of slavery and Jim Crow, which has a lot of complex effects in society that we're going to address by sometimes being race conscious, right? So if Congress were to do that, of course, the Supreme Court has enlarged its power by saying we get to say what the Constitution means. And we also get to say how much power Congress has under these clauses that I've mentioned, the enforcement clauses. But I do think that the times that Congress really asserted itself to establish a definition of constitutional guarantees was in the post-Civil War moment, as well as in the Civil Rights era. In the Civil Rights era, the Congress passed a lot of statutes that gave new meaning to what was in the Constitution. But now the question is, what is Congress going to do, or what, when you have a Supreme Court that keeps striking down, saying Congress doesn't have the power to do that. Congress's power to enforce voting rights under the 15th Amendment is limited. Congress cannot have a Voting Rights Act that tells states to be race conscious, right? That's essentially what the Louisiana versus Calais decision says. So I think now you're in a real bind, because Congress can just stand up to the court. They could just keep passing these statutes and have the court strike them down. But the Congress we have doesn't seem to really be in the mood for that. Vibes, I don't know. And I think over time, we have a constitutional culture in which the Supreme Court has been so respected. I think it's actually a relatively new thing that the Supreme Court, its popularity has really waned. And even when the Supreme Court's popularity wanes, I think most Americans accept that the Supreme Court is the final word on what the Constitution means and says. But there's a lot of interesting work now by legal scholars. I'm thinking of Daphne Vernon and Nico Bowie at Harvard. They have a new book coming out called Supremacy. They're arguing that there's no reason why it has to be that way. And they're not the only ones. Many legal scholars have said there's no reason why the Supreme Court has to be the last word. And Congress should just keep standing up to the court and passing statutes that just fly in the face of what the Supreme Court says. If the Supreme Court says color blindness, why can't Congress just keep passing statutes despite the fact that the Supreme Court keeps striking them down, saying, no, color consciousness is what the 14th Amendment after the Civil War about slavery was really about. Okay. Now, if we had that, you'd have what is typically called a constitutional crisis, because if you don't know who decides what's legitimate, that's kind of a crisis. It's a crisis of authority, and you'd worry that maybe someone would get violent. And we're already seeing a lot of political violence, a lot more than I think should be considered normal. But in any case, so part of the shadow court idea that forms the core of my book is what are some peaceful ways we could try to get Congress to stand up to the court and retake its role as the constitutional lawmaker in chief, because something went very wrong when the Supreme Court became the constitutional lawmaker in chief and all the people started accepting and respecting the Supreme Court's final word on constitutional meaning, even when the Supreme Court said things about what equality, for example, meant. That seems a little bit at odds with the way that a lot of people who've actually lived in this country think equal protection should mean. So, so how do we get Congress to act? I mean, so one part of the solution is we got to do something about partisan gerrymandering, because if people who get elected to power, if the parties that get elected to power keep entrenching and reproducing their power, then it's predictable that you're going to end up with a Congress that doesn't do a lot to stand up to a conservative Supreme Court. Okay, so that's a set of problems. But another set of problems is, let's say that you had Democrats in control of Congress. Even when Democrats are in control of Congress, you don't see them standing up to the Supreme Court. You don't see them passing tons of legislation that challenges the Supreme Court's questionable interpretations of the Constitution. And so the idea that I'm proposing in this book is, what if we had an institution, a shadow court? What if Congress actually said, we're going to pick 9 people? We're going to pick the people who would be on the court if you let us pick the justices. Right now, we let the president and the Senate pick the justices. But what if the House picked the justices? What if the House picked the justices listening to the people and let them write opinions? Let them write opinions on the most pressing constitutional issues before the Supreme Court gets an actual case that they have to decide that raises those pressing constitutional issues. What if people could bring generalized grievances? And this is not something I'm totally making up. So in the 19th century, Congress often heard petitions, which were basically generalized grievances. The First Amendment of the U.S. Constitution protects the right of the people to petition the government to address their grievances, for redress of their grievances. And in the 19th century, that was understood. Like, people brought petitions, and it wasn't just citizens. Like, people who were enslaved and women who couldn't vote would bring petitions to Congress, claiming we should change the Constitution, or women should be allowed to vote, or people should be emancipated. And Congress would sometimes hear them, and they would pass bills. Sometimes you could pass bills in Congress that were not like laws of general applicability. It's very interesting. And I'm not an expert on the petitioning process. You could look at work by Daniel Carpenter, who's a political scientist in the Harvard Government Department, or Maggie Blackhawk, who's a legal scholar at NYU. They've done a lot of really interesting work about petitioning in the early republic. But and so that gives you an idea. Congress is capable of acting as an institution that hears generalized grievances and takes positions on constitutional issues, right? The other really interesting thing that's more recent in memory is that the Senate Judiciary Committee used to have a subcommittee on constitutional amendments, and they had real hearings that were robust. It wasn't just political grandstanding. They actually had serious multifaceted hearings that looked at constitutional issues, because if you live in a world where it's actually a real possibility that you can amend the Constitution, and it's something that we think about every time the Supreme Court does something that people don't agree with. The Supreme Court, if the Supreme Court says the Constitution prohibits affirmative action because it's colorblind, one reaction is, why don't we amend the Constitution to be clear that race-conscious action to redress past injustice is allowed and possibly required, right? And you see exactly that happening in many European countries in the early part of the 21st century. This is something I write about a lot in my previous book, After Misogyny, How the Law Fails Women, What to Do About It. What's fascinating is in a lot of European countries, they start passing laws that require equal numbers of men and women in certain contexts, like a political party runs a list of candidates in an election, equal numbers of men and women, right? You have a law that requires that. Corporate boards for publicly traded companies, you need equal numbers of women, gender parity. And the Constitutional Court said, oh, that's unconstitutional because you have to treat men and women the same. You can't be gender conscious. And the reaction to those court decisions was they amended the Constitution. In countries like France and Italy and Germany, they amended the Constitution in the 21st century to say, actually, the law shall promote equal access by women and men to the vote and to elected office, right? So they clarified by way of an amendment, right? And we've done that in the United States before. So towards the end of the 19th century, the Supreme Court struck down a law that imposed an income tax, saying that the Constitution didn't allow for a federal income tax. And then we got the 16th Amendment. I mean, there was a lot of work that went into that. It's a very interesting and fascinating story. But after the Supreme Court strikes something down that Congress does, one healthy reaction in a democracy is to use the amendment process to push back against the court, or to essentially overrule the Supreme Court with a constitutional amendment. And there are a lot of reasons why the amendment process has kind of broken down and doesn't work. And you could argue it was always designed to be a little bit too difficult anyway. But interestingly, in US history, there are these moments where constitutional amendment is used to overrule the Supreme Court, and part of what makes it likely and possible, or at least something that people can imagine happening, is that we have a structure in Congress. We have the Constitutional Amendment Subcommittee led by Birchby in the Senate throughout the 60s, and we get the 25th and 26th Amendments during that time.
Yeah, I mean, if you look at the later 20th century and now, it's it does feel impossible to amend the Constitution, which is weird. I mean, when I know enough about international law to know to have a constitution with as few amendments as we have is actually quite strange. And particularly when we're the oldest written constitution. I mean, arguably the British Constitution is older, but it's not written down. We're the oldest written constitution on the planet, which I think also surprises a lot of people in the United States. But I was thinking about your some specific features of the shadow cabinet. You talk about why this might be important. You use a lot of examples from Germany and Austria. What specific features regarding judicial appointments, non-renewable terms, eligibility rules, and the constitution of the shadow court, which we'll get to what exactly it might be in a minute, could we import from foreign constitutional courts and constitutional just different constitutions abroad that might be useful to look at when looking at our contemporary problems. Particularly with one of the things that I think we've seen in recent years is both the right and the left are kind of getting mad at the Constitution now itself, which is a new kind of a new thing in my lifetime, and and I'm not super old, so I guess, what do you think we can import from other countries that might help, that would still be legal in our constitutional framework?
Yeah, so I think it's really important not to think of this as import or transplant, because that's just not possible.
Right.
And so I think we should, and that's why even the concept for this book is shadow court. It's borrowing and engaging the idea of shadow cabinets in many parliamentary democracies. It's a normal part of the way that the political opposition functions. So the political coalition that wins control of the government, then there's the opposition that lost, and what it means to live in a democracy in which winners and losers try to make the democracy work, even though they sometimes lose elections, is by forming a shadow government. The shadow government has no power, can't make laws, but they always remind the voters, this is what we would be doing. It's like they're shadowing, they're like on top of a watchdog, so that the people always know what the alternative is, right? In terms of policy, what would the shadow government be doing, right? So that's one idea. Then there's the shadow. So we take that shadow idea and then combine it with a very important 20th century institution that exists in many democracies, particularly invented after countries had some traumatic experiences with Nazism, fascism, autocracy, military dictatorship, and other forms of anti-democratic rule, including apartheid, government-imposed apartheid in South Africa, right? So what did they do? They created a special court called the Constitutional Court. And the Constitutional Court's job was to be a guardian of the Constitution. And it was not really like ordinary courts that just were case deciding courts. A lot of these constitutional courts decided problems before they actually hurt anyone. So for example, you'll note that in the US, you can't have a constitutional case until someone has standing, someone has an injury. And it's very, even though we find the doctrine allows us sometimes to enjoin a policy before it goes into effect. But in general, you don't litigate against laws before they go into effect. They have to go into effect and hurt someone before you actually have what we call a case or a controversy. But constitutional courts actually do what's known as abstract review. So the Constitutional Court decides on the constitutionality of legislation or even an executive order before it gets applied to a specific person, before we decide, has that person been sufficiently injured? And this is very important for creating a uniform rule in the country about what the Constitution means, and a decision from a court, a legal decision from a court about the constitutionality of some action taken by a political actor. And I think that is valuable. So if you take, for example, what happened with birthright citizenship, it's like it took a year for the Supreme Court to say that it was unconstitutional and to have a uniform rule for the whole country. A year ago, the Supreme Court said, oh, we can't have a nationwide injunction stopping the birthright citizenship order for everyone because district courts just decide specific cases. They can't enjoin a whole policy of the president for every possible application. Only the Supreme Court can do that. But the Supreme Court can only do that if it gets a proper case that's ripe and ready for its decision. A lot of these constitutional courts, though, they hear generalized grievances and decide constitutional issues before unconstitutional or allegedly unconstitutional laws go into effect. And the opinions that they write often gives like it's almost like a dialogue with the legislature or even with the president, with the executive branch, right? What you did was unconstitutional for these reasons, but if you did it this way or that way, it might not be so unconstitutional, right? You get opinions that look like that from constitutional courts. And in the book, I give a lot of examples of the way in which some of the work of modern constitutional courts have protected democracy in ways that would be useful here in the United States. But again, I come back to, we have a constitution that would probably make it difficult, unconstitutional to exactly import or copy or transplant either constitutional court's design, or any of the constitutional court's designs to the United States. So for example, I mentioned this earlier, I think that in democracy, you definitely want term limits for the people who are deciding these very important political, moral, constitutional issues. You want term limits because you don't want the same you don't want these people who are like out of touch because they've been up there for like 30, 40 years to continue to decide these issues, right? So you want term limits. And another thing you want, which is very common throughout the world, is you want a broader swath of democratically accountable actors to be appointing the folks who decide these important constitutional issues. You don't want just the president and the Senate, especially when the president is chosen by the Electoral College and the Senate is malapportioned, right? You probably want the House. You might want state governors. You might want state legislatures. You might want actually a national popular vote to name at least some of the people in the court. All of these things would not be constitutional if you conceived of a constitutional court as being an ordinary court within Article 3 of the Constitution. But if you think of it as not exactly a court, puts scare quotes around the word court. And in fact, in France, it's called Constitutional Council to show that it's not exactly a court, right? And the other problem is if you also have something that functions more like a shadow cabinet. Again, shadow cabinet is not really an official government entity. It's just the opposition decides this is how we're going to behave to strengthen our democracy. So if Congress were to say, we're going to create a shadow court, they're going to write these opinions, but the opinions don't have the force of law. They're going to write doctrine and jurisprudence, but it's not binding on anyone. It's just telling the voters, hey, look, if you had justices other than the guys who actually hold power, this is what our constitutional law could look like. So then it puts people in a more educated position in deciding how they're going to engage congressional elections. And in terms of the larger project, I think it also might put people in a position to better understand what the Constitution allows and doesn't allow, and perhaps lead to people advocating for constitutional change, not just constitutional change by bringing a case to the Supreme Court, but constitutional change by amending the Constitution or even thinking about changing the way that we amend the Constitution. These are very big long-term goals, and they might seem a little bit radical, but I just want to remind you that even the Constitution that we have from 1787 was a radical act. In order to amend the Articles of Confederation, which was the Constitution they had at the time, they would have had to get unanimous agreement by all the state legislatures. That's what the Articles of Confederation said. But James Madison and a lot of the framers said, well, the Articles of Confederation are not really working. If we keep going with this, the country might fall apart. We need a new constitution. And so they got together in the summer in Philadelphia in 1787 and wrote a whole new thing. And they knew that they would not get all 13 state legislatures to agree to it. So then they wrote Article 7 that said, this is going to become the law of the land if conventions in 9 states ratify it, right? So that's a little bit weird and interesting and imaginative. But then now they're held up as the geniuses that architected our Constitution. And in many ways they were. But if you take what they did seriously, I think it's not unpatriotic for us to think maybe this Constitution's too old. Maybe the institutions that it creates are not suitable for a vast multiracial representative 21st century democracy. And if that's what we really want, a vast multiracial representative 21st century modern democracy, we need to start thinking about new institutions that'll get us to maybe constitutional amendment. And the constitutional amendment might actually require broad consensus on a different way of changing the Constitution, period. And so I see the shadow court as a really small step in that direction. Create a new institution that's actually not going to be unconstitutional. Why is it not unconstitutional? Well, it has no power, right? It's just an institution that puts out ideas, but it's an institution that's designed to be representative, that puts out ideas so that the people can make better choices about the future direction of constitutional law.
Yeah, it got me to thinking about like why we don't have shadow cabinets ourselves, like because like that's totally legal in our own framework.
Yeah,
we don't do it for whatever reason. I know we're not a parliamentary system, so parties don't have the exact same kind of power that they do in the parliamentary system, but it's still fascinating that we don't do it, because it does mean that we're kind of guessing.
I think we certainly could do it. And I think in the last year, it has been interesting to see many Democratic politicians saying we should just do this. We should have a shadow cabinet. Here are some names. And I think there was a Zoom meeting once. And you also see sometimes the Democrats in the House have held shadow hearings, meaning they're not official, like they're not the official hearings of, say, the Senate, the House Judiciary Committee. But if you just like get a room and say, we're going to have the witnesses that we would call if we control the majority. And we're just going to have the hearing that we would have had if we had control. Right. I think that is useful because it provides information to the public. And so I do think that there has been more interest. But the problem is that it requires infrastructure, organization, and commitment. You can't just say, like, you can't just write an op-ed saying, here's who I think should be on the shadow cabinet. You got to get those people into a room on a regular basis to work out their policy agendas, and you got to have those shadow hearings on a regular basis. And I think part of the reason things like that don't happen, I mean, there are other problems with Congress. I feel like everyone I know who's in Congress, like, spends all their time raising money.
Yep.
You know, so if you like, there are only so many hours in a day and people have to eat and sleep. And I just think that, and part of the problem now is money in politics, which also has a constitutional law. And, you know, the Supreme Court's responsible for that problem as well, in terms of the expansion of the First Amendment to cover money in politics and the implications and just the material realities of that. But I don't think it has to be this way. And it's not this way in a lot of countries that have public financing of elections. But at the end of the day, a very large portion of the time and the emails sent by people in Congress is about like trying to get you to give them more money. They go to fundraise, you know, like raising money is like a huge chunk of what they do. And that's less time for like being part of a shadow cabinet.
It's also less time for actually legislating, but
that too. I think that's a bigger problem. Sure.
But like looking at this, I was just thinking like, yeah, my exact thought was similar to yours. It's like, oh, our parties aren't actually. The party system in the United States is you know, at a state level it's formal, at the national level it's informal, legally speaking. But like the DNC and the RNC's infrastructure is like hard. The RNC has more. Even when the DNC was better funded, it had more. But like, you know, right now the DNC is like millions of dollars in debt. So even if you're not in Congress, you're still probably just thinking about funding problems. But I do think it's important to think about this. I was thinking about the only kinds of things that are like this that we already have as a model. And your book mentions one of them, which is the Office of Legal Counsel for the president.
Yeah.
Could this be a model for something like a shadow court or an advisory court or both?
Yeah, absolutely. So part of what I try to do in the book is show that this is not a work of science fiction. This is not just like creative arts and crafts, political institution building time. But actually, like, we could look at some things that are real. And so we have a tradition dating back to the 1940s, I want to say, of the executive branch, the president, having a legal advisor, and the Office of Legal Counsel. The person who heads it is usually someone you would think of as a very, very good nominee to be at least a district court judge, if not a Supreme Court justice. Usually it's someone who has that kind of professional legal pedigree. And so if you have lawyers and very high quality lawyers in the Office of Legal Counsel traditionally, and they write opinions, the president, before the Supreme Court, before there's any case about it, before there is even an executive order, they might ask, is this constitutional? And so there is a body of published legal opinions by the Office of Legal Counsel. They're not even really binding on the president. President doesn't have to listen to what the Office of Legal Counsel says, but often does. And the Office of Legal Counsel, even though you could think of them as the president's lawyers, they're not exactly. They've been very independent in their judgment. Sometimes they deliver the bad news and say this thing that you want to do by executive action might have these constitutional problems, and you'll see those opinions, and they'll opine. And we've never really had an equivalent for Congress. So imagine like just an advisory, a body of legal advisors for Congress. We have some things that could be similar. Like there is a Congressional Research Service, which is a cadre. And not all of them are law people, but there's like a law division that publishes very good reports providing constitutional analysis on statutes and history of congressional action in a particular area. Those folks are not really like known quantities, right? They're more like career researchers who are sitting in Congress. The other thing is that, interestingly, I think there were some offices that might have existed at earlier moments that could be analogized to the Office of Legal Counsel that were in Congress. And historians are sort of studying that now, right? Where we're looking at some things that existed in the past and said, they offered legal analysis and legal judgment. And if they were stronger and more known, could they offer a counterweight to everything the Supreme Court is doing? And I think we need to learn from those histories. We need to learn from foreign models. We also need to learn from states. A lot of state Supreme Courts do advisory opinions. So I have a chapter that looks at that practice. I mean, of course, for the Article 3 judiciary, the federal judiciary, they decide cases and controversies. So we have many statements by Supreme Court justices, including Justice Kavanaugh in a decision a few years ago involving the abortion pill, where you have many statements where justices say, we don't give advisory opinions. That is not our job. We don't have constitutional authority to decide generalized grievances or give advisory opinions. State Supreme Courts, actually, their constitutions in many states say that upon request by the governor or the legislature, the Supreme Court shall give advisory opinions. They're not binding on anyone, but very interestingly, when the Supreme Court gives those opinions and they are well reasoned, it would be embarrassing if if the Supreme Court went through the trouble of providing a very well reasoned opinion and the people who asked for it said, nah, I'm just going to go with vibes. Right. And so even if they're not binding, they do have influence, and they certainly provide information to voters and the political opposition. So we can't federal judges can't provide advisory opinions because of Article 3 of the Constitution. But if you had a shadow institution that had no power, like a newly invented institution, of course they could provide advisory opinions because they're not real judges.
Right, exactly. It's just advisory anyway. The parties can do what they like.
Right.
They're not official government agencies. I guess, this brings me to the last chapter of your book, which is kind of a jump, and it's one of the most heartening and also kind of one of the most depressing parts of the book simultaneously. But when you talked about the way these kind of constitutional courts were created in societies that had gone through authoritarian periods that were democratically legal, even if, like, the Nazis never had the majority vote in Germany, but they had a plurality of votes. So you talk about using this as guardrails for democracy. We have obviously gone through something like this in our own history. I think you mentioned this already in the Civil War amendments. But how do you think we should look at these institutions rebuilding after a period of and it's not to make it just about Trump is actually a little bit misleading. This expansion of presidential power probably goes all the way back to World War I, but it's really accelerated in the 21st century. How would we use both a shadow court and maybe an actual constitutional court to deal with the problems that are emerging from a more and more authoritarian executive?
So I just want to be clear. The thing that I'm calling the shadow court would be basically a constitutional court for the United States, really functioning as an advisor to Congress on constitutional issues. I don't think we could just create a constitutional court that's transplanted from any of the foreign models that I look at. And we can't just kind of like dump it in DC and expect it not to be struck down. Right. So I want to be clear about that. But I do think that some of the work that constitutional courts have done provide, I wouldn't say models, but ideas for us. So one, I'll give you an example, and this is translating the example is hard. So, South Korea had military dictatorship. They got a new constitution in 1988. They created a constitutional court in 1988 to move towards a new model of democracy after decades of military dictatorship during the Cold War. So one of the things and obviously if you survive military dictatorship, one of the things you're going to be worried about is a president who uses executive power to enlarge his own and/or to subvert to weaken the other institutions. So what's really interesting in the South Korean constitution is that they actually have the constitutional court decide impeachment. So once the legislature impeaches, so in the US, we have the House of Representatives impeach, and then the Senate decides whether to convict or to remove a president from office after they've been impeached, right? So, but in South Korea, they only have one chamber of the legislature. The legislature impeaches, and then the constitutional court considers it a legal question, not a political question, as to whether or not the president who's been impeached has violated the Constitution in ways that make him removable from office or that lead to the removal. And so you see, it's a delicate thing, though, because if the court acts too politically on that decision, the court will not be respected and everything, all systems will break down. So the court, and so if you look historically, they've been very careful about exercising that power, but they've written these opinions really looking closely at what the president allegedly did and, whether or not, how much of a threat it is to the Constitution or the constitutional order. And I'm not saying that the court has always come to the right conclusion on this, but I think it's certainly an interesting model in light of many people thinking that the impeachment process in the United States is not really working. And if you take impeachment not working, and criminal prosecution of former presidents for alleged violations of criminal statutes in the exercise of their powers, like that's not really an option for stemming the rise of presidential power, Trump v. United States, then one question we might end up with is, can the shadow court play a role in providing legal, not just political, but legal analysis prior to the Senate's decision and giving constitutional advice to Congress during the impeachment process? And might we have different outcomes? If not different outcomes, might the people have a different understanding of whether their senators are making the right or wrong decision on impeachment?
Mm-hmm.
Right. So that's an example where you could imagine a shadow court playing more of a role in an impeachment process, which in our system is currently understood as political, not legal. Right. It could insert more law, doctrine, jurisprudence into the process of impeachment. Right. Another example might be, could a shadow court offer more jurisprudence doctrine that makes it possible to do something that doesn't seem too random and vibesy about partisan gerrymandering? Because the Supreme Court always says we can't really get involved with partisan gerrymandering because it's too political. There are no judicially manageable standards that we could apply to decide which forms of partisan gerrymandering are acceptable and which ones are like beyond the pale, right? And part of the reason the court can't do that is that the court doesn't really get these cases until there's actually a case or controversy, right? And if you don't get the case until there's a case, or like with all voting rights and election cases, it's really awkward. If you think about Bush v. Gore, which was happening my first year of law school, when the court decides something involving elections, it's usually because there has to be an active case or controversy. The court is deciding a general issue in a way where it's obvious who's going to win the election, like which party or which person is going to win the election, depending on how the court decides. So it's like, so yeah, it does seem like this is so political. Can they really do this in a way that's fair? Right? Now, if you say that if you have a constitutional court or even an electoral court that decides general legal issues around redistricting and voting rights more in the abstract, and before you have an active live controversy, it might actually be useful to impose some law on the process and to create some judicially manageable standards. You could have the shadow court doing things like that, creating the doctrines and the jurisprudence, but create the doctrines and the jurisprudence in advance so that the doctrine doesn't look like you're making it up to support your favorite candidate or party.
Yeah, I mean, that would be nice to have. These things do happen by individual legal scholars and scholarly reviews that no one reads. Are you know, and some ones I was thinking about. Unfortunately, the Heritage Foundation is not a shadow court, but sometimes acts like one in the worst way possible.
I certainly think we can be doing more. I think we do spend a lot of time educating lawyers as legal experts and legal scholars. And I think we need to be doing more to change the way that civics is taught and even the Constitution is taught to like everyone for K through 12.
Oh yeah, I work in. I used to teach government. I don't anymore. I now teach literature, but and I refuse to teach government because I don't feel like I can teach it honestly. By like state statute, I don't think I can teach it honestly.
Right.
So like, so I went back to being just an English teacher. But yeah, I feel it because most people don't understand. I mean, but like in Utah, for example, yes, you have to take like a civics test to graduate. That civics test is like half of the citizenship test. But that doesn't really inform you that much on like the actual workings of law, or how a lot of these things come up, the importance of case law, when an executive order matters and when it doesn't. Like these things that, they're not clear to the average person, and they're not taught in civics at all. I mean, I remember learning about executive orders in my, I think it was around 2000. It was around leading up to what we were just talking about, because that's when I was in undergrad. And being like, how are those?
Yeah.
How did that work? like
yeah.
No, this like at all. So yeah, it's been interesting to go. And I also had this naive trust that whatever the Supreme Court said was obviously true, because it was the Supreme Court. And, and in the 90s, opinions about the court, even the Windcrest court, was pretty high.
Of course, yeah.
So, it would have never occurred to me to go like, wait, did they just making this stuff up? Like, at the time. And it would be nice to have some bodies that would advise us on these matters, that had some force of, not law, because we can't, because of the Constitution, but some force of like infrastructure and stability, and that we're not just partisan think tanks. Like that seems to be well, let's thank you for your work. You mentioned you're working on another book, and I always like to have people tell me what they're working on. So what are you working on in the future, and where can people find your work if they're interested?
So before I wrote this book, I did a lot of work on women's rights and gender equality. And I got very caught up in many dimensions of the ongoing struggle for the Equal Rights Amendment in the United States. And it's obviously a very important issue for the women's movement and its evolution, but it's also a fascinating issue in light of how the US Constitution became unamendable, why that's really bad for democracy, and if there's anything we can do to make the Constitution amendable again. And it's bad for the Constitution to be unamendable, not just because we can't write women's rights into the Constitution, which I think is important, but actually is not the most pressing problem. The most pressing problem is that we have a lot of political institutions that were designed in the 18th century by people who just could not imagine the vast multiracial democracy we would become. And I think the institutions that we have, specifically Congress, the Supreme Court, the presidency, are not designed to be representative and responsive to the people. So if you take the people themselves, we the people, and the Republican form of government, which are in the Constitution, but I've just named at least two things in the Constitution that are not enforceable. They're just words and rhetoric. But I think there are words and rhetoric that actually speak to the values of what this country has always aspired to be, the only real through line in my mind from the founders to now. I mean, they were slave owners, and they had a lot of views that we may not share, but they did believe in we the people, and they did believe in Republican forms of government. And I think if we take those things seriously, we need to amend the Constitution or possibly write a new one. But we exist in a legal cage right now where it's not really realistically possible. So I want to try to think about how we can move short-term and long-term into a place of a more representative republic. And so the Shadow Court is the short-term book, but I'm working on the long-term book.
All right. Well, I'll be looking forward to it. I liked your work on the Equal Rights Amendment. It's actually how I found out about you. So,
thank you.
I'd be excited on figuring out how we can fix the Constitution. I do find it interesting that there's 20 conservative states right now who have been secretly, well, not so secretly, but very quietly signing up for another constitutional convention.
Well, I think people are very scared in America of a constitutional convention because it will open up a lot of things.
Oh yeah, including the dissolution of the country itself.
Right. It would open up a lot of things. So, and then this is one of the problems that we need to work on. Like, if we had a convention right now, do we have any reason to believe that it would not become a violent runaway free-for-all? We don't want that, right?
No.
And I think that's part of the reason we cling to a constitution that's so imperfect and fails us, because it's probably more peaceful or less violent than what would happen if you opened everything up with at least some forms of convention that are imaginable. So I think the work we need to do is think about how could we have a peaceful transition to a more democratic constitutional democracy. It's a very hard question, but I think I feel that's where I'd like to spend my work, my time. That's the work that I want to do for the foreseeable future, and I hope more people will.
Yeah, I hope more people do too. Thank you for your time. Have a great day.
You too. Thank you.
Bye-bye.